Alan Jackson is back at it again, getting ready to defend his client, Frazier Bohm, and talk about exactly why he thinks this case has been overcharged. And we're going to see here why he's pointing out that the prosecution isn't being consistent either. Check this out.
Your Honor, Section 995 exists for exactly this reason, to purge charges that sound great or rest on legally unsupported theories. The Supreme Court has repeatedly instructed that 995 motions must be granted when the magistrate applied the wrong legal standard, not just where the evidence is weak, but where the governing law and the governing elements were misapplied. And that's what happened in this case. It's precisely what happened here. Judge Edward did not get the law right. He accepted that there must be a number, there must be a speed theory, and that's legal error. The people continue to cite to the court outdated law, and that is legal error. The controlling standard for the objective requirement has never been met, and that's legal error. Once the right law is applied, the outcome is no longer discretionary for this court. It's not even close, it's not debatable, it's mandatory. If Reyes governs, and Reyes does, I think we're all in agreement, including Mr. Martins, that Reyes now governs. If the current CalCrim 520, which I placed on the court's bench, governs, and I think, again, we're all in agreement that it does govern, then the murder counts must be dismissed. The case comes down to this, and I'll close my closing comments are these.
Here we go.
There's one unavoidable question. Did the prosecution present evidence that Frazier Bohm committed an act involving a high probability of death at the time, that he knew it, and that he intentionally disregarded it? The answer is no.
I don't think so.
Not a little bit, not barely, not depending on how you look at it. The answer is just no. No intoxication, no racing, no text, no statements of indifference, no prior warnings, no subjective awareness, no prior serious consequences by the government, no bad driving in his history, ever. And no objective showing of a high probability of death to a near certainty. Just speed. And speed is not malice. Section 995 is that safety valve. The safety valve that every member of the community relies on. It prevents exactly this kind of overreach. And the law demands that the murder counts be dismissed so that this case can proceed on the proper charges. The charges the evidence actually supports. Manslaughter, not murder. We ask the court to dismiss counts 1 through 4. Thank you, Jesus.
Yeah, thank you.
Well said. Shout out to AJ.
Thank you. The defense rightly points out the change in CalCrim 520, including the language of high probability that that was the result. But they just ask a question if the people presented that at preliminary hearing. Well, it appears that the judge who held the defendant to answer believed so, when in his holding he said, quote, implied malice requires that the defendant act with a wanton disregard of a high probability of death. That's from the preliminary hearing transcript, volume 3, page 47, lines 14 through 15. The committing magistrate clearly understood the law and applied the law to the facts that he heard. And we're here for a 995 motion. And the question then is, were there sufficient acts for him to draw that conclusion? Understand, he was applying the very law the counsel's been saying he did. I did want to note one thing in terms of the high probability. One of the cases cited by the defense was People v. Pierce at 114 Cal App 5th 508. And in Pierce they confirmed that there has not been a fundamental change to the law. They say, quote, finally, we note that the defense contends the High Court in Reyes, quote, changed its position on the objective component of implied malice and redefined dangerous to human life as requiring a high probability that the defendant's act would result in death. Contrary to the defendant's argument, the requirement that an act carry, quote, a high probability of death is not new. And Reyes itself noted the equivalence of the Thomas and Phillips formulations, those which came before, restating that the language that already existed stood for the same thing. This is a refinement of the language. And in fact, in the Pierce case... 520 have to be changed.
No, because it's stating that this already exists, that this is not new.
This is the formulation. The change of 520 was a refinement in the language. The standard has always been that the failure to act, even from the previous language, the natural and probable consequences of the act were dangerous to human life.
That's not the same. That's not as stringent as the requirement.
It is different language, but the point was that that was the language that was provided to, in this case, a jury. And the court upheld the conviction, stating that the language was sufficient based on what was provided to the jury at the time. So the question now that we're facing is whether there was sufficient evidence presented to the committing court in order for there to be the order holding to answer. And the defense has said time and time again that speed alone is not sufficient. And speed in isolation is not the determination. Watson and all of its progeny, again and again, they don't provide any definition of what implied malice is. They talk about the circumstances and how every case must be evaluated on its own circumstances. There is no number that's ever provided by the court. This isn't a case of speed in isolation where the defendant was driving down an open road with no other vehicles, with no other cars, pedestrians, just flying and reaching high speeds. This is a case where the crime took place on a stretch of road that has homes on both sides, with driveways and garages leading directly onto the street, with other vehicles that were going the speed limit at the time that he was driving, cars parallel parking on the side of the streets, and pedestrians walking on those sides, given that stretch of PCH, which the defendant said that he was familiar with, doesn't have sidewalks. This was all information known to the defendant at the time that he decided to engage in the behavior that he did. The speed that we're talking about has to be looked at in terms of where he was and what he was doing. It isn't just that he reached the speeds that he did, he also had to navigate around other vehicles that were going slower. And that evidence was presented at the preliminary hearing. And that he went around because, even according to him, the vehicle in front of him was in his lane, so he drove around. And that's when he was reaching those high speeds. Now, he claimed that that vehicle then started to merge into his lane. So first, let me talk about that in terms of my moving paper saying that about the cause of the accident. The defendant's conduct was the proximate cause of the accident, or the collision, I should say. There is not evidence presented at preliminary hearing or anywhere else other than the defendant's statement that there was any contact between the defendant's vehicle and another. And the physical evidence shows that that did not occur. I don't understand where
The mirror was
the mirror was...
It was out of place.
It was out of place. The mirror was out of place in a position that one would not expect to have happened if it occurred while the defendant was passing another vehicle. One would anticipate the mirror would be knocked back as it struck, as it's moving forward, and it would be knocked backwards. The defendant's mirror was knocked forward. And that was after he had exited his vehicle. I could not say exactly how that occurred, but it does not appear that it would have come from striking that other vehicle. And certainly, being the fact that the other vehicle suffered no damage on its mirror. The important point then is that this other vehicle is part of the issues that the defendant faces when he gets his vehicle up to the speeds that he did, because people change lanes. And if the defendant is attempting to pass on the right at speeds of 104 miles an hour, and the vehicle starts to turn, he does not have sufficient time in order to control his vehicle. And I did want to point out that the one thing that the defense didn't talk about was the fact that the defendant said when that vehicle came into his lane, he swerved to avoid it. We had the electronic data from the airbag system, and that was presented and put into evidence, and there was no swerving to what would be the light to the right. The only inputs were still left. The only steering inputs at all were to the left, contrary to what the defendant said. And as I noted in my moving papers, and I won't go into great detail, but it does show that the defendant understood that what he was doing was dangerous, and he is coming up with excuses as to why the collision occurred.
What? How?
The other important factor about the speed and the electronic data control is that at the outset of its reporting, which occurred 5 seconds prior to the first deployment of an airbag and some 7 seconds before the final deployment, those inputs included an engagement of the stability control system, meaning the vehicle was not stable in its movement. In fact, we heard testimony at the preliminary hearing from Miguel Cucino that he observed the defendant's vehicle skid, lose traction with the road as he saw it then speed off. He said he could see the puff of smoke. According to the electronic data, that occurred when the defendant was doing 93 miles an hour and had his accelerator at 79%. He continued to accelerate for another 4 seconds after the vehicle lost traction with the road. As the court said, this isn't just he's going faster and doesn't notice, as Mr. Jackson said. He is being warned by his own vehicle that he does not have control, and yet he exceeds even that speed, which is already far above the limit.
But doesn't that show negligence though? How does this show malice? Again, I'm not an attorney. I'm asking you guys because people just like us are going to be on the jury. These are important questions that need to be answered. How does that show implied malice though? But to me, that seems like recklessness and negligence.
He is being warned by his own vehicle that he does not have control, and yet he exceeds even that speed, which is already far above the limit, and continues on to what the data reported as 104 miles an hour. How could he not have known? In regards to the defense saying that we are relying simply on a slogan to prove that the defendant had subjective knowledge of the dangers of his speeding. It was the defendant himself in the statement who turned the slogan into something personal to him, that he had 2 of his best friends die as a result of speed.
What?
The defendant had the knowledge. He admitted that he had the knowledge. The issue is, as Mr. Jackson pointed out, does that mean that forever he could be charged with murder if he exceeds the speed limit by a single mile an hour? And the answer is no. Probably not even 5 miles an hour. Probably not 10. It has to be that he exceeds the speed and does acts that demonstrate implied malice. And here, that's exactly what we have. He knew that the speed, and he said that he believed it was 130 miles an hour, caused the death of his 2 best friends. Again, I'm not saying that the number is 130, but he clearly has an understanding that these excessive speeds can result in death. And it's not certainty, it is more than remote, or and I want to get the language right. In one of the citations, and this is from Reyes, citing People v. Cravens, the quote from a concurrence of Justice Liu, although an act that will certainly lead to death is not required, the probability of death from the act must be more than remote or merely possible. And that is absolutely what we have here based on the totality of the circumstances and the totality of the acts that the defendant engaged in, understanding that he had been driving in a manner prior to the excessive speed that was described as going from all the way to the shoulder, all the way to the other side, that he was engaging in behaviors that already drew the other driver's attention to him. And then, at that point, he decided to speed at such excessive speeds. And when I say excessive...
Yeah, so the reason they keep hammering this home is because it's going to look bad in regards to the implied malice here for Frazier if they can show, and which it seems like the prosecution has been able to show, that his car was giving him warning signs and saying, hey, something's wrong. And then he continued to push the accelerator down to 70%. So that's why they're continuing to hammer this home and say, okay, well, maybe it wasn't the slogan that he saw, speed kills, but his car was beeping, it was flashing, it was showing him something, and he still proceeded forward at that rate of speed. Now we can say there's implied malice here.
Excessive. We're talking about the actual speed limit was 43% of the speed that he reached. He was exceeding the speed limit by 231%. And as the court noted there, this isn't...
That's not enough for implied malice. It's a point. It's a brick in the house that they're trying to build, but come on.
Just about the speed. It's about his knowledge and about where he is engaging in this excessive speed. And he said he knows PCH like the back of his hand. If he knows it like the back of his hand, he knows that people are putting out their trash cans. He knows that people are parallel parking. He knows that people cross on the crosswalk that is demonstrated in the exhibits that the defendant passed as part of his path towards where the collision took place. He knows this, and yet, with that knowledge, with the knowledge that he is already losing control of his vehicle due to the speed, he continues to press down that accelerator for another 4 seconds. And that totality is the basis that the magistrate used to hold the defendant to answer. It is not that there has been no evidence, that there has been an abundance of evidence, that more so than is needed. But the point is, at this hearing, it's whether that evidence was presented sufficient for the magistrate to hold the defendant to answer, and it was.
Very briefly, first of all, first thing I want to mention is the math is wrong. It exceeded the speed limit by 230%. The math is wrong. The speed limit was 45 or 50. 230% would be 145 miles an hour. That's absurd. 100% is double. 100% on top of that is the 45 again. So let's get the math right. It wasn't. Was he speeding? Sure. But I don't want to get ridiculous about this. 230 times? I want to know, what the hell is he in a jet? You got the math wrong. Let's talk about facts.
That's funny.
Provable facts. Mr. Bartos says he was speeding. Okay, that's in a bucket. He's been saying that from day one. He's searching, and the prosecution has been searching and grasping at straws for anything other than that. There are homes at the side of PCH. That's dangerous. There are driveways leading out to PCH. That's also dangerous. There's cars parked along PCH. Boy, that's dangerous. There are trash cans. People have to put their trash cans out. That's dangerous. There's no sidewalks, and yet there's still pedestrians crossing the street. That's also dangerous. He went around some slower traffic, so says Mr. Bartos. Is that dangerous? Maybe, maybe not. And going at a higher rate of speed gives you less time to react. It's also dangerous. Where in that list did Mr. Bartos establish a high probability of death? That's the standard. The prosecution has gotten into this spin cycle non-stop since the preliminary hearing. Boy, this was dangerous, this seemed dangerous, this is dangerous, this is dangerous. That's not the law. As the court rightly termed, the jury instruction, it was changed for a reason. The Pierce case didn't stand for the proposition that it's all the same. It's always been a high probability of death. That's not true. The Reyes case changed the law. And the jury instruction was changed because of that, as the court noted. We are not talking about something that's dangerous. Is excessive speed dangerous? If we go out on Van Nuys Boulevard, whatever the big boulevard is, I think Van Nuys Boulevard, outside the courthouse, how many folks are going to be speeding on that road? We can look for 10 minutes. How many folks are going to be speeding on that road? Nearly all of them. Nearly all of them. It's California, for God's sake.
What you're talking about right now.
Fair enough. Fair enough. I'm making the point, but I don't mean to upset a community, but I'm making the point that speeding can be dangerous, probably is dangerous, but it doesn't in and of itself reflect a high probability of death.
What circumstances would, in your mind, represent a driving that evinces a high probability of death?
If he was high. But it was
whether you're high, you're drunk, or whatever it might be, equally, and you're therefore likely to cause some kind of accident. Who's to say whether this accident with drugs or that accident without drugs is more likely to happen to hit a vehicle or a pedestrian and kill them?
Let's say that there's a circumstance in which
Isn't there a large degree of bad luck?
luck is not enough. It has to be, yes. Sometimes accidents always happen to a certain degree because of bad luck. But the question becomes, when is it elevated to murder? That's why manslaughter exists, Judge. That's exactly what you're explaining is why manslaughter exists. Because sometimes people are doing things that are inherently dangerous, they shouldn't be doing it, it costs somebody their life. In every manslaughter case, it's important to reflect. I'm not standing up here asking that the entire case be dismissed. I'm saying let's call it what it is. In every single manslaughter case, every one, someone died. By definition, someone lost their life. If what Mr. Bartos is saying is right, basically, well, the car has a system on it that engaged. It was a traction control system. The car's telling him what he's doing is just about to lose control of the car. Well, first of all, that's not how traction control systems work.
That's not true.
There's a beep that goes off or a light that goes off on the dashboard. You never hear it. I've got traction control in one of my cars, and you never know that it's going off. It's embedded in the EDR system, but it's not tapping the driver on the shoulder and saying, hey, slow down. That's not how it works.
Yeah, and that also, I'm sure AJ's going to get to this. I should not interrupt. That's rude. It also doesn't say, hey, there's people down there. You're probably going to kill them if you keep driving like this. I'm going to let AJ cook that.
The question to answer the court's, the answer to the court's question is, what would show a high probability of death? Street racing. At 100 miles an hour on certain streets. High probability of death.
Why is that anymore?
Because
more likely
street racing
to cause death than just driving 100 around?
Because street racing by definition is competitive, and you're constantly trying to outperform the other car. It's coordinated, and you're intending to go as fast as your car will possibly take you. That's the point of street racing. Street takeovers, where you're doing donuts surrounding pedestrians. Nearly every one of those cases that's prosecuted, if a pedestrian gets clipped by a car drifting in circles, gets clipped and gets killed, nearly every one of those cases is prosecuted as a murder. Why? Because it's not just excessive speed, it's losing control of the car on purpose with a pedestrian standing five.
Not on purpose.
Drifting is losing control of the car going out of sorts. In other words, driving it in a manner in which it was not designed to be driven. It's drifting, by definition. So you have far less control. No car is designed specifically for that. It has to be in the hands of a professional. So these street takeovers, they kill people all the time. And normally those are prosecuted as murder cases. Why? Because it has the added effect. You're not just speeding like on the 405 to get around slower traffic. Driving on a sidewalk. Driving when you're evading police. There's always an additive to just speed. That's what Justice Evans was saying.
What about the environment? Mr. Parker sort of touched on an example that I was going to raise as well, which is, don't you have to consider the environment and the circumstances? There's a difference in the risk of death in driving 100 on PCH versus, some, far out, desert road where you're on a straightaway, there's no other cars, and nobody's around, and you can just go at 100 and not have to turn the wheel. There's a difference between that and driving on a dangerous crowded road like PCH, isn't there?
They're both dangerous, but neither one of those, by just driving fast alone, neither one of those include a high probability of death. People do it every day, Judge. On PCH, they do it every day, and no one dies. It doesn't include a high probability of death. This is an incredibly high burden. We're not saying that it wasn't dangerous. I'm not suggesting that there wasn't a possibility that someone could get hurt. I'm saying that there was not a high probability of death such that Frazier Bohm should be saddled with murder charges. These are the same charges that Bryan Kohberger is facing. Oh. That's the point. Bryan Kohberger broke into a dorm and slaughtered 4 people. He's facing 4 counts of murder, a plea deal. 4 counts of murder. It's murder, Judge. That's the point. That's what the magistrate misunderstood. Is it dangerous? Sure. Is there a possibility that someone could have gotten hurt? They did get hurt, so clearly there's a possibility. Was there a high degree, a near certainty, as the Moore case put it? Was there a near certainty, a high probability that someone would die that night at that time, and that he knew it and disregarded it? The answer is no. It's resoundingly no. We don't have to like it. I'm not asking anybody to like what happened or to justify what happened. I'm asking the court, call it what it is. We are objective purveyors of the law. That's what we do for a living. We don't use emotion. We don't supplant tragedy for the law. We don't supplant emotion for the law. It was tragic. It was emotional. It's devastating. But it wasn't murder.
Woo, this guy. Is that opening statements? Are we seeing a preview of opening statements? He said, Your Honor, Bryan Kohberger got charged with 4 murders. And he planned this whole thing. He went up there, he bought the knife, he showed up to the house, he followed him, he waited until it was dark and quiet. That's not what this man did. Dang, AJ is out here cooking. Let's see if he got some more.
Thank you.
Jeez.
Anything in response to that, Mr. Parker?
The only thing is the evidence was sufficient for the magistrate, and he was correctly applying the facts to the correct law. Anything beyond that would be this court using its own decision-making, which is not 995. It's simply the determination whether there was evidence presented on which the magistrate could rely, and there was.
Submitted by vote.
Submitted, Your Honor. Thank you.
Thank you. So first of all, the Third Council is aware, I'm going to put on the record made that standard 4995 motion. According to the Lighthouse, the Superior Court case, 67 Cal 2nd 471, reasonable probable cause is shown if a man of ordinary caution or prudence would be led to believe and conscientiously entertain a strong suspicion of the guilt of the accused. That's the magistrate's job. The Mandela case, 1983, 33 Cal 3rd 754, reaffirms that the magistrate's finding of probable cause should stand if supported by any rational interpretation of the evidence. If there is some evidence supporting the magistrate's conclusion, the information will not be set aside. Some evidence. People versus Superior Court, Decker, 2007 case, California Supreme Court case. The reviewing court asked whether the evidence provides a rational basis for believing the defendant could be guilty of the charged crime. Every legitimate inference that may be drawn from the evidence must be drawn in favor of the information. The judge in my position is not to reweigh the evidence or judge the credibility of witnesses. At the 995, the question is whether there was simply probable cause to hold the defendant to answer, and that's all. So I'm going to discuss facts here, and then I will discuss the law that applies to counts 1 through 4. There's no doubt the defendant was driving extremely fast on the PCH. All of the witnesses described it. They put different numbers on it, but they all said things like he was going, quote, extremely fast, or he, quote, flew past me, or he was going, quote, super fast, or that he, quote, accelerated extensively. The data recorder in Mr. Bowen's car said he was doing close to or even above 100 miles per hour in the instance before the crash in a 45 zone. The magistrate noted the data recorder evidence carried weight in his decision-making, acknowledging that while there are warnings that come with it that say it can make mistakes, there was no evidence presented at the preliminary hearing in this case that it made errors here. The defense said that Mr. Bowen was fleeing a road rage incident with Mr. Victor Calandra, but there's no evidence of that in the record. The evidence in the record was that Mr. Calandra, when stopped next to the defendant at a light a few moments before the crash, rolled down his window and warned the defendant he needed to be careful, yelling at him, "You need to be more careful, you're going to hurt yourself."
Yeah, I mean, if that's the case, it's going to be tough. Again, the judge is going to lay out all the reasons here why he is going to deny the motion to dismiss these charges. But I think AJ, the reason he took this case is because he has a great defense here. And we've seen AJ say before in an interview that his goal is not to get Frazier to be found innocent. Although We believe and he believes he's innocent until proven guilty. He's not saying that he didn't commit some sort of crime. He is saying that what he's been saying here the entire time, he's been super overcharged and it should have been maybe manslaughter. And then we can go and defend this and say why we believe Frazier is innocent. So moving forward, y'all know we're going to cover this case. I think this is going to be a great one. Let me know what you think about this in the comments in the